Excellent. Thanks very much, Matt. I'd also like to acknowledge that we're on the lands of the Jagera and Durable people. I kept thinking Ngunnawal, thinking Canberra, given you were talking about ANU, but we're not there, we're here. And also to recognise my long ties with Unconventional in Central Australia, and a project I'm working on at the moment is with Jingli and Woodburra people in the Beetaloo Basin region of the NT. Okay, so the transition to clean energy entails not only more mining for the critical minerals needed to decarbonise, including for gas, as a supposed energy transition or transition energy, but also the burgeoning footprint of renewables, wind and solar, on the Indigenous estate. This paper will begin to trace the constellation of risks and opportunities that are emerging for Indigenous rights and interest holders, both in general terms and also via a brief consideration of a region that embodies this pressure. I'll also discuss information justice in relation to the agreements that are negotiated with native title holders. This is a photo that I took almost 2 years ago of a slide from a PowerPoint presentation at a critical minerals workshop. You can see the head of the Commonwealth staffer. Here we go, just tiny. Sorry, I cut most of him off, poor thing. Down in the bottom left, he's the staffer who led the development of the federal government critical minerals strategy. They're predicting that global demand for critical minerals will be such that 30 new lithium mines will be required, 11 new cobalt mines, and 41 new nickel mines, and so on, will all be needed. This same narrative was the focus of the World Mining Congress in Brisbane in late 2023, where the Federal Resources Minister, Madeleine King, told the Congress that, quote, "We will need more mining, not less, to meet the demand for clean energy technologies such as wind and solar farms as well as batteries." As Minister King says, quote, "We all have a role to communicate the importance of the mineral sector in supporting the transition to net zero," end quote. This narrative, however, focuses on the decarbonisation agenda. The fact that many of these minerals are also used for the defence and space sectors is backgrounded, and I'm not able to readily find figures about what proportion goes to that sector. But when we're talking about the local impacts for the greater good, the moral imperative argument is not as compelling as it might be. The Australian Government's critical minerals strategy has 6 focus areas, and 3 of them include developing strategically important projects, regulatory and policy frameworks that are fast and efficient, and First Nations engagement and benefit sharing. As the strategy states, the government will support the sector in regulation and financial support, which includes, quote, targeted support to accelerate development of critical minerals projects. For instance, last year, the federal government announced that it was investing $500 million in a rare earth refinery in Western Australia. Critical minerals represent a familiar stock of geological product with existing markets, ready-made producers, supply chains and consumers. The notable variation is the urgency attributed to their use in renewable energy technologies to avoid catastrophic and irreversible climate disaster. As Owen and co-authors have written, this existential threat creates a new context for analysing resource markets. Not because the activities themselves will be atypical, but that the urgency could override established market norms. Certainly the language of de-risking investment is concerning. The strategy as an international sales pitch seemed to have worked with the US in the recent signing of the MOU. Yet the strategy positions Australia as a responsible supplier of critical minerals, underpinned by strong social, environmental and governance or ESG credentials. Indeed, as a, quote, first leader in ESG performance. In the First Nations engagement and benefit sharing focus area, they're seeking, quote, genuine engagement and collaboration with First Nations communities that promotes benefit sharing and respects their land and water rights. Though the strategy is silent on how this is to be achieved, so there is some obvious room for interrogation here. There will be some more mining in some places. A recent article by some of my colleagues at UQ analysed the socio-spatial spread of a critical mineral endowment across Australia in terms of local government areas, or LGAs. They found that Australia's most disadvantaged LGAs host the highest number of critical minerals mines and mineral deposits, and that likewise some of Australia's smallest LGAs, and with some of the most limited governance capacity, host the highest number of critical mineral mines and also prospects and deposits. Across these 31 LGAs, there's a mix of small populations of residents and highly mobile FIFO or fly-in, fly-out populations. In such a context, the fair sharing of benefits in these regions is unlikely unless strategies are specifically developed to address this distributive challenge. For instance, in the Nganyandarako Shire, and you can see that's just south of Halls Creek, just up here, Nganyandarako Shire. It's very remote WA. It's the most disadvantaged shire nationally, according to the ABA. Yet they already host several nickel cobalt deposits with small workforces, and since 2021, BHP's West Musgrave project entered construction with a FIFO workforce. Maps are really helpful in thinking through both the temporal and territorial aspects of energy transitions. This map includes all listed critical minerals and their stage of development, overlaid with the Indigenous estate. This estate includes not only native title and areas of Aboriginal land in the Northern Territory and South Australia, but also areas of the conservation estate that are less formally held. And as we know, the customary estate is the whole of Australia. Given the locations, most existing and proposed critical mineral projects are on land subject to native title determinations or applications. So any questions about this map? Can you all see it clearly enough? Or okay, I'm open to questions if there are any. So as I'm sure you're all aware, one of the most important factors explaining land access and benefit sharing agreements that result from mining oil and gas is that native title holders cannot legally veto these developments. This is due to the nature of extraction rights as legal rights that can be enforced against all landholders, including those with freehold title. The only exception to this is under the Aboriginal Land Rights Act in the Northern Territory and some areas in Northern South Australia, where they have a form of free, prior and informed consent, or FPIC, which is a type of veto. Native title holders only have been able to prevent mining oil and gas developments via legal avenue 3 times, once in 2009 and twice in 2011. In comparison, resource companies have been successful in gaining legal permission at the arbitral body, the National Native Title Tribunal, despite a no from native title holders on 153 occasions. Such low odds undoubtedly discourage native title holders from pursuing arbitration. And of course, if they are unsuccessful, as they're likely to be, they also miss out on negotiating an agreement. So if they say, no, bugger off, we don't want any mining here, then they don't get a seat at the table. So the right to negotiate, which native title holders gain with their successful determination, is inherently coercive. If they don't pursue that right, they have no seat at the table. Sorry about the map. Okay, it's not a very good map for the Northern Territory. So along with the right to mine, industry also has the right to explore. Vast swathes of the continent are covered with exploration licences for mining oil or gas. So yeah, apologies for the graphic. So this example of one jurisdiction, the Northern Territory, is probably an anomaly, as 50% of the area is Aboriginal land with veto rights. As you can see, there are areas without exploration licence applications or ELAs. So the yellow is Aboriginal land, and you can see in the top of the Northern Land Council area, there are quite a lot of areas there without ELAs, and that's probably because traditional owners would have said no. Likewise, in Arnhem Land, there are some areas in Arnhem Land in the far northern area where traditional owners just say no means no, you can come back, but we're still going to say no. So there's a moratorium for 5 years under the Aboriginal Land Rights Act when the mining companies can come back again. But clearly, a lot of traditional owners do say yes to mining and exploration. So these ELAs, exploration licence applications in most states and territories, attract the expedited procedure under the Native Title Act, which is important to revisit in the current context of critical minerals. As a reminder, the expedited procedure is a fast-track process for future acts that are considered to have minimal impact on native title, including the grant of exploration or prospecting licences. Under this procedure, a government party can notify native title parties of the proposed act and assert that it will have minimum impact. If the native title parties do not object within a specified period, and I think it's 4 months, the act can proceed without a full right to negotiate process. If an objection is raised, the parties may negotiate, or the Native Title Tribunal will determine if the expedited procedure applies. The use of this procedure for exploration in critical minerals is likely to become more common, as there is a risk that governments can assert that the right to negotiate doesn't apply, thus circumventing the need to make an agreement and fast-tracking the process. Certainly the language of the critical minerals strategies indicates that this is the likely path. One of the grounds on which a native title party can object is that the notified procedure affects areas or sites of significance. However, for a representative body, which would be a native title rep body or a prescribed body corporate, to be able to respond to all of these ELA applications, they have to be very well resourced. The reality is a lot of Aboriginal organisations do not have the resourcing. And my understanding is that those groups without recognised native title and a well-resourced rep body, they've got very limited recourse until the company is actually at the stage of building a mine, in which case an EIS process is triggered, environmental impact assessment is triggered, and associated cultural heritage processes at the state and territory level. So that's when they have recourse. A review of the Future Acts regime by the Law Reform Commission is underway, which is one of the recommendations from the Jukan Gorge inquiry. So they'll probably be having their findings will probably come out quite soon, I'd imagine. So now I want to turn to the growing clean energy footprint and some of the differences that are emerging in consultation and consent processes for Indigenous rights and interest holders in this space. Because large-scale renewable energy projects were not a thing when the Native Title Act was established, approvals for these types of projects are not specifically considered by the Act. And when these projects were just emerging, it was not looking hopeful for native title holders, as the degree of power that they have over these sorts of developments depends on the interpretation of Section 24KA in the 1997 Native Title Act Amendment Bill. And as this is legally complex, and I'm not a lawyer, I'm not going to get into the weeds of this. Suffice to say that this section relates to infrastructure operated to provide facilities to the general public, such as airports, roads and power lines. So initially, researchers working in this area, this is from 2021, had considered that because this section provided an exception to the standard right to negotiate for certain future acts for these general public use infrastructure projects, there was no need to compulsorily acquire native title rights or fully negotiate with native title holders, unlike for mining projects. Okay, so however, more recently it's looking more hopeful. So this is 5 years on. The same researchers who were saying there's no hope, they've actually now done some more research into this, and they've seemed to have accessed some agreements, which is very unusual, at least some high content level agreements. So this is Kath Thorburn and Lily O'Neill. They've found that native title holders can withhold their consent for renewable energy projects. And this graphic has been borrowed from their recent article. It'll come up again. Yep, here we go. So it comes and goes a bit. Okay, as they say, native title holders can almost certainly say no to clean energy agreements. This is because the Native Title Act does not have an approvals pathway under the Future Acts regime designed for clean energy projects. So agreements that deal with native title consents are likely to take the form of Indigenous land use agreements. So they are likely to be able to negotiate. Although there can be significant power imbalances present in these negotiations, as ILUAs or Indigenous land use agreements are entirely voluntary. So this makes it very likely that a developer cannot obtain relevant government approvals without the consent of traditional owners or native title holders in this case. And they suggest that this looks very much like a veto. That's their finding. This is unlike the process under the Native Title Act for extractives, which provides 6 months for the right to negotiate and no veto rights, as discussed. So they have suggested or found that there are currently 14 registered ILUAs on the native title register for solar, wind and energy. Though as at earlier this year, the term renewable energy wasn't actually a search term. So it's still radical and new, clearly. Okay, so this slide highlights the key differences between the extractives and renewables, including that there's usually some flexibility where renewables can be located, whereas mines are tied to an ore body. This also suggests that there's more scope for protection of cultural heritage in renewables as a result of that flexibility. So there are almost 1,600 Indigenous land use agreements across Australia, but the vast majority of these are confidential. It's experts in industry, in law firms and large Indigenous organisations that have access to these agreements. Not only access to the details, but the trends in benefits and payments. I want to briefly touch on this information access disparity in relation to the ILUAs and other agreements. So this information disparity keeps knowledge in the hands of these expert advisors and disempowers First Nations groups who are forced to pay for such advice. Drawing on O'Neill and Thorburn, and also Farclay, who's just at Griffith across the road, there are at least 4 compelling reasons why, at a minimum, core aspects of these agreements should be made public. And these are the use of good agreements as templates for future agreements, reducing transaction costs and increasing knowledge of best practice, greater analysis across agreements, particularly where agreement making is achieving its often stated aim of improving the lives of host communities, increasing the accountability of industry to pay fair rates for land use and behave in a socially responsible manner, and increasing the accountability of those receiving payments to fairly distribute these payments. In many cases, this is internally. The amounts received are confidential even to the wider group. So locally amongst Indigenous rights and interest holders, there's obviously jostling and competition for these resources. So yeah, their research also highlights how small the pool of expertise is in Australia in relation to agreement making for renewable energy projects. And they've come up with a number of 15 people who are predominantly lawyers and financial professionals. Okay, so finally, I just want to briefly turn to the Northern Territory, where I've done a lot of work in particular. I'm deep in a research project with the deceptively bland title of Pathways to Indigenous Socio-Economic Development in the Beetaloo region. So this is a collaboration with traditional owners and native title holders across the Barkly region. And so though at this stage of the research I don't have licence to discuss the project in any detail, I can talk about some preliminary findings via some of the issues that are in the public domain. So as you can see on this map, the Beetaloo region is that blue area, and that blue area is where there's apparently a lot of unconventional gas, which is the gas fracking, deep in the ground. So I guess it's a bit of a geological term. So this very remote region has become a large-scale development hotspot. It's now host to a burgeoning network of unconventional gas fracking wells and associated infrastructure. The proposed largest solar farm in the southern hemisphere, Suncable, 2 of the most contested mines in Australia, which is the MacArthur River and Beetaloo Creek mines, and industrial-scale agriculture, notably cotton. So MacArthur River mine is just up, can I point on here? So the MacArthur River mine is just up here, and Beetaloo Creek is down here. The fracking is here and over here, and the cotton is around here, and potentially Larimer is around here. But yeah, there's just a lot of activity and a lot of other exploration for other minerals, including critical minerals. So unlike most other areas in Northern Territory, there is very little Aboriginal land in this northern Barkly region. It's pastoral lease, overlaying with native title determinations. And what makes it remote is not only its location, but it's also on the fringe of 2 regional shires, the Roper Gulf and the Barkly Shires, so service delivery is particularly poor. The constituency of both these shires is predominantly Aboriginal, 70% in the Barkly and 75% in the Roper Gulf. However, they're also distant from both the Northern and Central Land Councils, both of which service the area. Gas fracking has been a particularly contentious issue in the region and has divided families and communities, including within the pastoral industry, as they also don't have any rights of veto either. The idea that natural gas is a transition fuel doesn't play out on the ground, given the huge investment via state and federal incentivisation of the industry, so the carbon lock-in effect is the case here. The first of these gas companies has finalised the Illawarra for its appraisal gas, connecting to the MacArthur River gas pipeline, which you can see on the map, while another is finalising infrastructure to also sell its appraisal gas, connecting to the Amadeus gas pipeline you can also see on the map, which goes north-south. So that's from the Central Australian gas fields. That's not fracking down there, that was a different form of gas. Almost done, yep. So the gas is neighbour to the soon-to-be-built Sun Cable solar facility as one of the world's largest solar farm and battery systems, covering up to 12,000 hectares on land on Powell Creek Pastoral Station. So Powell Creek is just about 70 kilometres south of Elliot, just to the west of the highway. This $22 billion Australian ASEAN Power Link project is to include at this stage a 3 gigawatt solar farm. They originally said 10, it's gone down to 3, I noticed the other day. On this pastoral station. So the transmission line would connect the system to Darwin as phase 1, and a 3,750k undersea cable would then go from Darwin to Singapore as phase 2. The Illawarra for this project was signed a few days ago in Elliot with the native title holders, and it has the state and federal EIS approvals. According to the news reports, almost finished, the agreement is for an unprecedented 70 years. And includes a commitment to providing local training and employment opportunities. As the Sun Cable CEO said, it's a very comprehensive benefits agreement. It does incorporate skills, training, employment, protection of local environment. But I'd rather that we kept exactly what's in the agreement confidential to the native title holders of the Sun Cable. So all of these Illawarras are important mechanisms for native title holders to benefit from these activities. But yes, we're encountering this issue of confidentiality. Though, of course, traditional owners are entitled to land use compensation and royalties, good agreements also go much further, in including wider community and regional benefits that focus on social impact, support for energy security and diverse forms of employment. A significant risk is that these agreements, which are unprecedented in the region and perhaps Australia, will primarily consist of royalties in the form of direct payments to a small group of traditional owners. And taking a strengths-based approach, a focus on the research is actively seeking out existing Aboriginal corporations, cooperatives and other governance mechanisms, including customary governance, as good practice examples. I've just got one small paragraph. So one of these is based at the Marlinger Aboriginal community, which is about 20 kilometres just north of Elliot, near Newcastle Water Station. So the NGO Original Power, under which the First Nations Clean Energy Network also sits, has been working in this community for almost 10 years to enable and support them to build their own solar microgrid. However, energy security is only part of the equation, as this organisation recognises that the clean energy transition offers opportunities for regional development, as community members are involved in project planning, installation of rooftop solar panels, and receive training in electrical technology and carpentry skills. Residents have also participated in the National Power Makers Training Program, which provides an in-depth overview of the clean energy landscape, its policy, regulations and investment, and the intersections with First Nations rights and interests in land and sea country. Though in many ways the community-led development at Marlinger is a poster child, there are other less visible Indigenous-led initiatives that are seeking development on their own terms in the region that the project will also be providing a platform for. And I'll leave it there. Thank you.